Hi everyone.
Hi,
Hey,
I'm
good morning, everyone.
so I think we can start. Hello everyone and welcome to this very insightful panel. I'm Tatevik Karapetyan and I'm the director and co-founder of Resolve Academy. So I just want to say that this webinar is jointly organized with Mediation Chambers and also Resolve Academy, and I have here my colleagues Alex and also Meline. So today we are going to talk about mediation in contract disputes, and we have a very insightful panel with moderator Aruna Verma and speakers Rajesh Sharma, Shreyash Jayashmi, and also Jonathan Fiore. So Aruna, I give the floor to you. You can continue. Thank you very much.
Thank you. Thank you very much. So firstly, I'd like to welcome you all to this event. So good morning, good afternoon, and good evening to you all from wherever you are joining from. We have an excellent panel here with us today from all over the world as well. But just to introduce myself firstly, my name is Aruna Verma, and I'm a trained mediator, an associate professor in law, and also a solicitor. And I'm working currently in the UK and dialing in from the UK. So I'd like to introduce our panelists, but before I do that, I'll just introduce the title of today's session. So contracts are the backbone of commercial relationships, but what happens when they are breached? So a very common question. So it's all happy when contracts are formed and relationships are formed, but what actually happens when something is breached? So we'll be discussing key issues, and I'll have some questions for the panel as well. I will make sure that I leave enough time at the end for questions and for you as participants to ask any questions. The chat box will be monitored, so if you have any questions as we go along, please put them in the chat box, and I'll read out the questions at the end. So we want to make this as interactive as possible, so please do put your questions in the chat box and we can get those answered as well. So one of our panelists is Shreyas Jayasima. So he's a graduate of the National Law University, National Law School of India University, and he has over 23 years of experience in litigation and dispute resolution. He's been representing clients across various sectors before the Indian tribunals and courts, and including the Supreme Court. He's a trained mediator and arbitrator, having served as co-counsel for the Republic of India in significant investment treaty arbitrations and in various domestic and international commercial arbitrations. However, in June 2023, he was appointed to an expert committee by the Ministry of Law and Justice to recommend reforms to arbitration law in India. Additionally, he is a member of several legal committees, including the Executive Committee of the Foundation for International Arbitration Advocacy in Geneva and the Mumbai Centre for International Arbitration Council. And he co-founded SEMA Law Pte Limited in Singapore to advise on Indian law. So welcome, Shreyas. Next, we have Dr. Rajesh Sharma. He is an associate professor at RMIT University in Melbourne, Australia, and joining us from Melbourne today, where he leads the graduate certificate in dispute resolution and directs the IDRRMI RMIT Dispute Management Centre. With a background that includes teaching at the City University of Hong Kong, he specializes in mediation, arbitration, and negotiation. Having trained extensively in these fields, including at Harvard Law School, Dr. Sharma has conducted significant research on mediation laws in Asia and provided expert comments to the UNCITRAL on various mediation topics. He's also established unique moot competitions that combine arbitration and mediation, and he's actively involved in several international arbitration and mediation organizations. He contributes to the field having earned him the ADR Teacher Award in Australia for 2022 and 2024. So welcome, Rajesh. And finally on our panel, we have Jonathan Abella Fiorentina. He is a partner at Mamo TCV Advocates, specializing in mediation, and joins us from Malta today. He specializes in ADR, litigation, and general civil and commercial law. He earned his doctoral degree in law from the University of Malta in 2006 and a Magister Juris in European and Comparative Law in 2007. He was called to the bar in January 2007. He initially focused on intellectual property law before joining Mamo TCV in 2015. In 2021, he became an accredited mediator in civil and commercial matters after completing the London School of Mediation's training and registering with Malta Mediation Centre, enhancing his expertise in dispute resolution. So welcome, Jonathan. So now that we have introductions from our panel done, we'll now move on to the actual discussions. So just to start off, we're going to split this into 3 sections. So our first section is understanding the landscape of contractual disputes. So as a starter, what kind of contract breaches are most commonly seen in commercial disputes? So what kind of contract breaches are most commonly seen in commercial disputes? So if we start off with Jonathan, perhaps?
Very good. First of all, good morning, good afternoon, and good evening to everyone. I would like first to take this opportunity to thank both Mediation Chambers and Resolve Academy for organizing this and for having me on this panel. It will be, I'm sure it will be a very interesting discussion. Yes, to address your question, I believe I would classify the most common breaches in 2, although in reality, as I will explain, one can form part also of the other. So I would say that the most common breaches can be classified as failure to perform obligations, which may seem obvious, and also the other classification that I would make separately, although I know that it may fall also under failure to perform obligations. The second classification would be, in my mind, failure to pay. As I said, although they are distinct, I think that they can be linked, as I will explain shortly. So I will first address the first category, failure to perform obligations. I think the most common breaches there that fall under this category would be non-delivery of goods and services agreed upon in a commercial contract that can take the various forms. It could be late delivery, so you have delivery but it's late. It could be non-complete delivery, or else it could be absolute total non-delivery of the things, the goods or services agreed upon. Another example of and a common breach that I have seen in my experience as regards failure to perform obligations is, and this is very common in my view, delivery of goods and services that are not according to to standards. So it could be both agreed standards in the relative contract, or it could be the accepted standards in the given industry. So it could be that a commercial agreement doesn't stipulate the precise standards being agreed upon. However, you would have accepted industry standards that would obviously be applied. And then you would have instances of general non-performance. So you could have obligations clauses in a commercial contract, and there is non-performance of those specific clauses contained in the agreement. Then to address the second category that I see, as I repeat, I know it is linked to the first category, but I would deal with it separately, which is failure to pay. and which obviously in Malta and also I presume in a lot of other countries, it is the cause of a significant source of disputes. Now, failure to pay, again, it could be a partial default to pay, so a part is paid, for example, a deposit or maybe a first payment, and then payments are stopped, or a absolute complete non-payment. Now, I think, so this is a very common breach. But I think one would have to see, especially in the context of dispute resolution and particularly mediation, one we need to see and understand, in my view, the reason why there was a default in payment. And here is where I think the two categories of failure to perform obligations and failure to pay, this is where they are linked together. Because you could have no reason at all. So you could have someone, a party to a contract, that fails to pay without a reason. In Malta, we call them that they are cowboys. So they enter into an agreement and then they play the cowboy game and they just fail to pay. Then you could have also failure to pay because the party in question is insolvent, has become insolvent, and obviously that is a particular situation which needs to be addressed, possibly also and most likely in liquidation proceedings. But then, and here is where the link with the failure to perform obligations comes through, is when you have a party that fails to pay because the other party has breached an obligation in the contract. And here is where it gets more complicated, in my view, because you have a breach, so a party failed to pay, but that party is alleging that, listen, I didn't pay because the other party didn't perform. The other party didn't give me the goods at the agreed standards or acceptable industry standards. And ironically, although that is where it gets more complicated, and here to link it with mediation, ironically, in my view, this is where mediation would be really effective, because you don't have just someone who doesn't pay, as I said, for no reason at all. You have a debate. Someone is alleging the other party, and both have breached the contract essentially, but you would have to see the reason why. And I think that is where mediation works best. To conclude from my end on this, so that I don't take a lot of time, one other instance which is interesting, I believe, and is common, is where you have alleged breach. I describe them as alleged breaches. So you would have a party that alleges that the other party has breached the agreement, when in fact, in reality, it's not the case. And then again, it's a bit a complicated case. Just by way of an example, just a very recent example, which I can mention to illustrate this. In fact, I have just filed arbitration proceedings in this case, very, very briefly, because it's a bit complicated. But the other party is alleging that my client has delayed in the performance of the obligations that had to be done. And my client is saying, listen, it's true, I am delayed, but it's because there were other contractors before me that needed to finish something and I couldn't start. And the other party has terminated the agreement, so they are alleging that there is a breach of the contract on the part of my client because they have delayed in performance. But it is an alleged breach because the delay in performance was due to the breaches of other contractors that had to finish the works before, and they didn't. So that is also another instance, and an interesting instance, of common breaches and contractual disputes.
Thank you, Jonathan. It seems like all of the elements of a basic contract can be breached and have been breached, but failure to pay stands out a lot for various reasons. So thank you for your insight on that. So what we're going to do is we're going to move on. So Shreyas, perhaps I can ask you the next question. So we've been through what kinds of contract breaches are most commonly seen. What are the typical causes of contract disputes in commercial settings, in your view, please?
Thank you very much, Aruna, and thank you for the organizers for this opportunity to participate. Just a quick correction on the introduction. I'm based in India, so I'm based in Bangalore. CIMA ADR is indeed set up by me in Singapore, but I'm based in India and practice out of Arna law, and I'm qualified both as, all three, as a counsel, arbitrator, and mediator. But back to your question, the causes are, frankly, the matter of, that's where the story lies, the meat of the story. And the magic or the promise of mediation is to let that unravel. In a court or in an arbitration, it's almost as if the causes are passé. They are merely incidental to the occurrence of a breach. And then the focus is on whether a breach has occurred and what the consequence of the breach is. Now, the charm and the opportunity and the human element is to explore as to what caused the breach. For example, it could be ambiguous or vague terminology in the contract. On this call itself, you see people from so many nationalities, and I speak English with a capital I, we say in India. We may be speaking the same language, but I may speak it with a different accent, and the words in the same language may carry a different meaning. And therefore, entirely sincerely and genuinely, there may be a misunderstanding even amongst people who speak the same language, from the same industry, who think they're reading the same word, but each is taking away a different meaning. So ambiguity in terms, a difference in understanding of those terms are some of the mild and benign causes of disagreements. They may also be scope issues, such as the definition of what exactly was to be done and the definition of the obligation. And there may also be instances of scope creep, where what you had initially contemplated has not actually transpired. Finally, there may be two other somewhat unpleasant circumstances. One, beyond anybody's control, acts of God or force majeure or even unforeseen changes. And we are seeing this increasingly so in 2025. Each of our lives, wherever it is in the world, I can promise you one thing, that there is a lot of change in each of our lives. And that change is radical. And the change is sometimes permanent, such as AI. And the consequences of this change is very different in every part of the world. And therefore, by definition, we are each experiencing unforeseen and rapid change. And this will undoubtedly have an impact on contract. So that's one change, is one thing, change beyond our control. The second and the last point I'd like to make is misrepresentation or fraud. Unfortunately, not every contracting party keeps to the word that they have made. And unfortunately, many times, the contracts are often entered into with a false premise. And so fraud, in its most basic sense, is the suggestion of falsehood or the suppression of truth. In either event, these are despairingly common in commercial contracts, both domestic and international, and one must exercise extreme caution in diligence prior to contracting, and also monitor the process of the working of the contract before merely jumping to resolving a dispute. And therefore, this point goes to behavior and goes to intent, and it can be mitigated by a strong contract compliance, diligence, and dispute avoidance program, for which mediation is very well suited. Back to you, Aruna.
Absolutely. Thank you, Shreyas. And that last point takes us quite nicely into a segue into my next question, which Rajesh, perhaps you can take. So how do parties usually approach resolution before considering mediation?
Thank you very much. I was so engrossly listening to my two previous speakers that I thought that I'm just an audience here. I was so involved in that. But very nicely they put it, all the causes of the contract and the types of contract dispute. But what happens first is the one thing happened, the two parties who are in love with each other to sign a contract or make a deal, and they always announce in person or in press release, they always announce this is our long-term relationship. They always want to do that. But suddenly what happens? That something goes wrong and then they become enemy of each other. And that's again, it's a like, psychology part or like human element comes. But apart from the human elements come, the one thing we should look at that why? What has changed? Apart from the circumstances, act of God or the force majeure or like, timing has gone wrong or the preconditions not met, all those things are there. But the one thing is very surprising is that when they want to resolve the dispute, the first thing happens that these two parties is stop talking to each other, and they do not even talk to each other. And that's why every time the other person who is like, wants to take any action, they run and they start litigation or start arbitration, whatever their dispute resolution system is, they start going over there. And that's why we always suggest that every party should remember one thing is that CCBD is like consider consulting before deciding. So always think about that, because that's the key part. And in short term, we also like, when we tell the younger students, we always say that uh, always pick up the phone before picking up the gun. Means before you start the litigation and all those things, pick up the phone, talk. And this is the part like where the parties, they do not do that. If they do, if they talk, even if they are in trouble, that's okay. But at least tell the other side that what the problem is. What is the problem? Then the parties will start discussing what to do. For example, we talk about the quality, we talk about the delivery, we talk about the time. Okay, if a party cannot deliver in certain time and they are running out of time, then at least they can tell the other side that, look, sorry, I cannot deliver it in time. Can you extend the time? That can be easily fixed. And that we can see. And classic example is during COVID, every buyer and seller, they were ready to supply the goods, but only because of the travel restriction, they could not supply. And the contract was breaching at that time. But why they didn't sue each other? They didn't take any action. At that time, they wanted to have the preserve the relationship and they didn't want to do anything. So this is the lesson we need to learn, that if we talk to each other, we can resolve. And that's the point. I'm not even going to the mediation side. At this time, I'm saying the parties to party, even before you fight, at least you talk and tell them, doesn't matter if you do not want to do the business, at least you tell them that, sorry, I do not want to do business with you because of this, or because of your false promises, because of your misrepresentation, whatever. Say it first. And that makes a very big issue in that one, and very big difference. And that's why our suggestion is that early talk it, tell them. Even if you disagree with them, at least let them know that why you are disagreeing. Even if you do not want to do the business, at least tell them. So the one thing we always suggest, that maintain the communication channel. Even if you are unhappy, not agreeing, say it, tell them. Even if you have a problem, you can easily solve it. And sometimes the company may have a financial crisis at the crunch time, when the payment comes or the installment comes. That's okay. At least you are getting late, then you can say that, sorry, in this month I cannot pay, or next month I cannot pay. So at least you inform them beforehand. And I think in the business sense, giving a prior information, telling them beforehand that I'm running in difficulties, those kind of a communications are very important. And that's why before you go to mediation or before you start anything, is the negotiation. Not even negotiation, I'm not even saying this is a structured negotiation. This is just to consult each other, confirm with each other, inform each other. And that's the very important part that we should look at that. And that's why, and different contracts, it can give you that. For example, which Jonathan was talking about, the preconditions of a contract, where somebody has to do something, they did not do it, so how the other party can do it. It's a very common problem in the big contract, it happens. But in that case, nobody is there to tell them. that this is what happens. And that's why, if you look at that, in a great, or now it is almost understood that one way to mitigate any dispute, avoid any dispute, or nip at the bud is the thing is that talk to each other, communicate with each other. And whether you use a third party or you use anything or you have a direct communication, if you do that, 90% of your problem can be resolved at the very earliest stage. And this is considered as one of the toolkits recently adopted by Ancestral just 1 month ago. And they say that this process is it's very useful to resolve the dispute at very early stage when it doesn't even become the dispute. So these are the few things we can take it. So key point is a communication. Just let each other know that what is the problem.
Yeah. Thank you. Thank you. So a huge message coming out of there, which is clear and open communication with the other party before even going to mediation or going forth onto litigation. Brilliant. Thank you. Thank you, Rajesh, for that insight. And it's good to see that various other organisations are putting that in, like you said, into the toolkit to ensure early resolution as well. So just to finish off this segment, this section, can I just ask Jonathan a quick question? So are there any particular industries where mediation is specifically and especially effective?
Yes, thank you. On this, I will take inspiration from what Rajesh was saying just before me, especially the first part of his intervention. And I would say that mediation would be especially effective in those industries and sectors where there are ongoing relationships. Rajesh was talking about relationships and maintaining communication. And I think that is where, if they fail to speak, as Rajesh was explaining, or they speak but they don't reach a settlement and then they proceed to mediation, those instances where there are relationships, ongoing relationships that are healthy relationships and should be maintained, I think there is where mediation is especially effective. Here I would think about employment relationships and commercial relationships in general. Then I would say that mediation would be highly effective, and I think it is highly effective for various reasons, which I will refer to some of them, in technical areas. So what comes to mind here would be shareholder disputes, construction and real estate, insurance, intellectual property disputes. So these are areas where you have, they are business focused. So I believe that the parties involved there would, their main intention, their principal intention is to maintain relationships and not to fight for years in court. So that's why I see that mediation there would be highly effective. And also because there may be specialized knowledge that is required in order to solve the dispute that they have and to find a tailored solution for that dispute due to its technical nature. Because what happens normally, at least in Malta, but I'm sure also elsewhere, in courts, I mean, the judges are not technical people in all areas, so they would, the outcome of a court case in a technical dispute sometimes, or often I would say, would ultimately, in the judgment, the court would give a solution that is not tailored. I mean, one party wins, the other party loses, but it doesn't really fix the problem. So that's why I think that their mediation would be highly effective. Just to other points, I think it would be effective in industries. Obviously, this is linked to the previous point, really, where there are significant financial stakes involved. So it would be much better, I think, for the parties to opt for mediation rather than arbitration or court litigation due to the financial stakes involved. And the uncertainties sometimes that are linked with litigation in court. And therefore, it's an extra risk that I think parties would not be willing to take. And finally, to conclude, I think it would also be effective in disputes involving the state and community, let me call it the general community. Here, what comes to mind is specific sectors in the community, like health, for example. If you have a dispute about, I don't know, a collective agreement that the state and the doctors' union cannot reach an agreement on it, I think mediation there could help. And also, for example, education. If you have a dispute between the educators, teachers, and the state on some conditions or something, employment conditions, etc. I think those are cases where mediation would be very effective in the interests of everyone involved, not only the parties. For example, I mentioned health and education. In health, also the patients will benefit, even they are not a party to a dispute. And in education, the students will also benefit if the dispute is not protracted over a long period of time.
Okay, thank you. That's really useful to know what kind of areas that mediation can help. Now, let's move on to mediation itself. Then, mediation as a strategic tool. Then, so what makes it a strategic choice for resolving contract or disputes? Then, Rajesh, what do you think? What makes this a strategic choice?
Yes. Before we use that mediation as a tool for resolving dispute, I will also say that don't look at mediation only as a tool for resolving dispute. It is also a tool for avoiding many disputes or mitigating many disputes at any time. And that's why I said that look at the timing part of that. How you can use the mediation. The very first time you can do it is that you can use the mediation or a mediator or facilitator to even negotiate your contract. If you do that, then the mediator as a third party without any interest in the outcome of the contract, at least he can help the parties that how you should make the contract. So the problem which Shreyas was talking about, the language issue, the timing issue or clarity issue, that can be sorted out because the mediator from the expert, from his skills, they can tell you that your language is not correct. I mean, I dealt with a case where it was a confusion between the parties if the payment is due in 5 days or Fridays. So they didn't know. So they have like a difficulty. One party was saying, no, it was only on the 5th day and somebody was saying, no, every Friday it was that. So even the language part or even the dispute, which we have seen, classic dispute where the one word like provided that if, even that word has been like, interpreted with the help of linguists. Those kind of a dispute, a mediator can do very well because the mediators are trained. They will alert the parties that your contract, your terms should be very clear and it should be who has to do what, when, how, where, and the consequence that will be clear. So I suggest that the mediation can even be used for the facilitating a negotiation for the deal. We call it deal mediation, for example. You can also use mediation during the project, during the life of the contract. Over there, the mediator will work as a supervisor, the somebody looking from the top. He knows the timing and everything, so he will say that okay, goods have to be delivered, or the building has to be delivered by certain date, and there is a timeline has been given. So even few weeks before the timeline, he will talk to the both sides and say that are you on the track? Would you be able to do that? And by just alerting them, you can solve so many issues. If you are running late, then they will suggest that, okay, why don't you take the permission from other side and extend the date? That will be much better. So that's during the, we say that during the life of a contract, which we also call it project mediation, or you can have a standing mediation approach kind of a thing. The third one is when the dispute already happens and when you want to use mediation to resolve the dispute, you can, of course, that do it is a very standard one which everybody knows. But I can tell you, mediation can also be used if some dispute has not resolved through mediation, has gone to arbitration or litigation, and then the award and judgment has come. You can also use the mediation after that, after the post-award situation and after the judgment situation. You can again sit down and work it out about the implementation or even or changing the terms of the award and other on your own. Like if $1 trillion has been given as an award, then you can talk to the other party and say, okay, I don't want that one. We can reduce it or we do everything. So even post-award situation also you can use the mediation. So mediation is not just, and of course, during the arbitration and during the litigation also you can do it. Many times the lawyers, after fighting the case, when the evidence are tendered during the arbitration, where the arbitration and mediation combination is very like familiar. Over there, the arbitrators also ask the parties that, do you want to continue? Still you want to continue for the arbitration, or do you want to discuss among yourself? And most likely after that, the party say that, okay, let us discuss one more time. So the mediation can run as a parallel track. Mediation can run as a start, in the middle, during the other dispute resolution process, and like post-award situation, apart from the mediation as a stand-alone dispute resolution system on its own merit, on its own right. So now we need to think quite big in that one, how we can use mediation for different purposes at different time and at different uses.
Absolutely, yeah. So it sounds like you can use it at each and every stage of the process of the dispute. So good. Shreyas, I know that you wear multiple hats. As counsel, arbitrator, and a mediator as well. But just focusing on your mediation hat, what would you say are the key advantages of mediation over litigation or arbitration in a contractual dispute?
Thank you. And again, thank you to Rajesh for explaining and evangelizing that mediation is always relevant. Mediation is always in the room. You just have to invite it to speak. And I want to begin with a dad joke that, often I say that meditation and mediation are misspelt with one with the other, but it's more than a Freudian slip. And the deep reserves of inner peace that meditation brings almost physically manufactures peace, not only with oneself, but also the ability to share it with others. And this peace seeking and peace making requires a lot of inner work. So the two are deeply connected, meditation and mediation. And that leads me to the benefits. More than anything else, the human experience is rounded. There is no sharpness in the relationships in the commercial context if mediation is attempted sincerely, irrespective of whether it succeeds or not. No regrets of having tried to, I could have done better, because mediation gives you that vacuum without legal consequences to say sorry, to speak out your hurt, and where your the emotional cause on your sleeve, and communicate in a way that is unrestrained by the fairly dogmatic rules of communication, that hidebound procedures, especially of litigation, but equally of arbitration. And therefore, it allows you to exercise creativity and party autonomy in its truest sense. It also, in its best outcome, can preserve relationships. It can deepen relationships, and it can, if successful, it is unsurprising that there is a high degree of compliance with a successfully mediated agreement, as opposed to something that is left unmediated and goes straight into either dispute of litigation or arbitration. And most obviously, it saves time and cost. I want to make one last point before I close the mic, which is that it is not a process merely before tumbling down the descent of the cliff of disputes. This is always available to you, irrespective of the stage of the dispute. And therefore, I find that many times the resistance does not come from parties. Unfortunately, I have to convince many of my fellow professionals to say that it's quite all right for us to get out of the way and allow this particular dispute to be settled without worrying about loss of income. There'll be another one coming along soon enough, don't worry. And it's an enlightened self-interest to make sure that you are creating a reputation for yourselves of facilitating and spotting early on every opportunity for successfully resolving a dispute. It requires the attention of all parties and all professionals.
Thank you. Thank you very much. That's very comprehensive. So now that we've decided that mediation may take place in a case, how would a party prepare effectively for that mediation, Jonathan, please?
Okay, so this is a very interesting question, and I would start by linking with what Shreyas has just said in his last point, and I would say that it's not only the parties that need to prepare effectively for the mediation process, but also lawyers. Perhaps I would say even most importantly, lawyers need to prepare themselves effectively for mediation. In Malta, just a bracket here and aside, mediation is not mature. It's still its early stages. I have the privilege of working at the moment on behalf of the Chamber of Advocates to introduce better mediation processes, raise awareness, etc., because it's practically totally absent, and we're in the process of developing awareness and promoting mediation, giving information sessions, etc., etc. And I'm saying this because it's linked with this question. In Malta, clients depend a lot on lawyers. It's like the lawyers are an extension of their being in a dispute. And I think that if the lawyers themselves are not prepared to go into the mediation process, I think that there is the tendency to reduce the mediation process to a court case, to litigation. And obviously that's not the intention of mediation. And I think we end up in that situation because there is a lack of understanding on both on parties' side and also on lawyers' side. There is a lack of understanding of what is mediation, and I would say more importantly, what is the scope of mediation. Therefore, I think that lawyers, first and foremost, myself being a lawyer, need to understand how the mediation process works, what is the scope of mediation, and perhaps the most important thing in the case of lawyers is to understand what is their role in mediation. And they need to understand that their role in mediation is different from their role in litigation. And unfortunately, this is not understood well, or at least not yet. They need to understand that they have a role to play in mediation, but it's different, as I was saying, from litigation. So they need to understand when they need to speak, how to represent their clients during mediation. I'm not saying that lawyers have to abandon their clients in mediation, but they need to guide them differently from how they would guide them. I describe it as in court, a lawyer represents the client. In mediation, the lawyer really assists the client. Now, as regards the parties, I think first and foremost, I may be stating the obvious here, but I think, and I believe Rajesh referred to this previously, I think that the most important thing is for the parties to enter and engage in the mediation process in good faith, irrespective of the outcome, of the final outcome of mediation. But they need to enter and engage. I like to use the word engage in the process in good faith. That will be, I think, that it's a big step towards a possible successful mediation. Because sometimes you see it. You see, when I act as mediator, sometimes you see that the parties don't want to be there. They are not engaging. They are just doing it just for doing it, especially if it's the mediation is referred by the court. So also, I think that the parties need to really understand what the dispute is, what the real dispute is. Again, this is linked to what my colleagues were saying previously. sometimes it's like a snowball, no? There's a snowball effect. There is a dispute, it gets bigger and bigger and bigger as time passes, and in reality, if they analyze what the dispute really is, what commenced everything, they would find that it's a, I may use the word small, it's a small dispute in reality. All the other things, it got big uselessly, sort of. There is where the mediator needs to play a role as well. So the mediator needs to make the parties understand and identify the real dispute between themselves. Because there would be a lot of ancillary things that can be sorted out quickly if they understand what the real dispute is. I think an important part of preparation on the part of parties and also lawyers would be to set targets, at least by way of a guideline, not necessarily they set a target and say, I want to achieve that necessarily, because that would defeat the scope, I think. But set targets as a guideline to where you want to arrive. So that would help them in identifying their room of maneuver, how much they are ready to give and take, etc., etc. I think they should also coordinate well with the lawyer. So in preparation for the mediation, I think they need to discuss a lot, and both the parties and their lawyer need to understand their roles in mediation, when to speak, how to speak, what to say, how to go about it, etc., etc. The most obvious thing that comes to mind is when you have mediation sessions, mediation processes, where it's only the lawyer who is speaking. I was involved recently in a mediation as a lawyer, not as a mediator, where I was allowing, because I know how mediation works, I was allowing my client to speak and explain himself, etc., etc. The mediator was trying to build, to have a conversation, but the other side, unfortunately, they didn't speak. Nothing, not even a word. It was only the lawyer. So there, obviously, it didn't succeed. And I think the problem there was the lack of coordination between the lawyer and the client, and understanding that the client needs to speak and understanding when the lawyer needs to speak. Then obviously there are other, what I call in inverted commas, natural preparatory work that can be done, like preparing to manage emotions, keeping calm, maintaining respectful demeanor, all these things. So it's the emotional preparation, sort of, and mental preparation. And finally, I think it's the final point, but it's not the less important point. I would link it with the first point I made about entering and engaging in mediation in good faith. I think the parties in preparing themselves need to be prepared to place trust in the mediator. Most probably they would not know the mediator. So they need to be prepared to place trust in the mediator, understand that the mediator is not there to judge or to decide. And therefore, they need to trust the mediator and trust also the process. I think that is very important.
Thank you. Thank you. That's very comprehensive. So we've had a look at so far why mediation, the causes of mediation. We've had a look at, as you've all spoken, we picked up some great nuggets of information and best practices. I'm just going to spend the next sort of 5 minutes finishing off in segment 3 before we take some questions from the audience. So even with its benefits, mediation isn't without its challenges. So Rajesh, what are the most common obstacles to successful mediation in a contract dispute? So what are the obstacles to overcome?
First obstacle, I will say that is more like a mental block, because the people are not accepting mediation as a process of dispute resolution yet. And that's the thing. And even our well-informed lawyer friends have the same difficulty. And I can give you one example. When the Singapore Convention was deliberated and the discussion came, and it's why we need that. Because after the mediation, we will have a contract in any way. It's still a contract. And the contract, we know how to resolve it and how to enforce it. That was the first mental block to understand, that people were not understanding that this is not a simple contract. This is a contract, is an outcome of a dispute resolution process. It's a different than the first contract where the two parties are negotiating and coming to a deal. And now it's totally different thing. So that was the biggest problem, like the mental block. Second, we are missing one point in mediation, is the mediation is not for the lawyers. It's not the lawyer's business. Best user and the main user of mediation are the business people, are the clients who are there. It is for them. It's not for the lawyers. And that is the point we are missing. If the businesses or the parties, they know about the mediation, they value mediation, then they can instruct the lawyer that I am hiring you to go to mediation with me or to do the mediation. That part is not happening in arbitration, in litigation. The same party is hiring a lawyer and giving them instruction to go to court or to arbitration. That thing is not happening. For that, we have to do some work in educating them and training them. The third one, which they were saying, the good faith, Jonathan was talking about it, is good faith is nothing, because we are not preparing those clients. How the clients will know what to do in mediation if they do not know how to negotiate? And for that, they need to understand, say, for example, what they want. And in general terms, we say, what is your interest? What do you want? In order to understand the interest, you just don't say that, what is your interest? You will not. There's, oh, I want money. Everybody wants money. But the question is, or the magic question is, why and what for? And this kind of a question, a mediator can also be very helpful at that time to coach the parties that how to go and do the mediation or what to do in mediation. So that coaching part is also very important for the team. And this is what the mediator will do. Whatever the party will ask, they will just keep on asking this question, why and what for. And that's how the peeling the layers of onion to go in the core to find out actually what do you want. And that part is there. So that's the preparation can really help us in that. And the lawyer part, when it comes, that when the lawyer is there, the main concern for the lawyer is that if the case is settled, then they will lose the money. If the case will go for litigation and arbitration, then they will make more money. But I don't worry too much about it, because even when the arbitration started, all the lawyers were saying that, oh, arbitration is useless and we will lose money. But now they are all accepted that. So this change will come over the period, it will come. But one thing is that we have started is called the mediation advocacy. Mediation advocacy is a part where the lawyer can deal with the client, not deal, but the agreement with the client. Assuming the big business, if they will go to dispute, and if this message goes out, their stock price will start crashing. So by losing that money in their stock, they can lose quite a lot. If the same thing, if a lawyer can help them to reach an agreement in mediation, resolve the dispute in 1 day, 2 days, or 3 days, short time, they can avoid so many losses of the company. So they need to deal with the company that, okay, whatever the loss I achieve for you or avoid for you, we can get some money in that. Then don't ask me to charge you only per hour, which we will charge. So then in that case, the lawyer will also say, okay, fine, I finish this case, collect my money, and then move on. So the fee will not be like $500 per hour type, or like something we bought. So this mediation advocacy part is also important, the lawyer to understand. I'm not against the lawyer. I want the lawyer to be in the mediation. There's no problem. And another thing we have to prepare, and Alex and we did the 2-3 years ago, third party funding in mediation. It is not everywhere in the rule, but it is happening in practice, where the clients are getting the funding from a third party to start. Of course, the third party funding in arbitration is known now. It is acceptable now. But actually, the case doesn't jump directly from dispute to arbitration. It goes through mediation, and the third party funders are there. So you also need to coordinate with them and work with them. So that's how, like, these are the challenges. So mental block and the little bit of that preparation is good.
Yeah, thank you. So just moving on, I've got 2 final questions. So just to notify the guests that are here with us today, if you've got any questions, please do add them to the chat box. We'll be taking them shortly. So Shreyas, what qualities make a mediator particularly effective in commercial contexts? please.
Thanks. I've already mentioned meditation. It's not, but it's good to have, not a must-have. But I think the essence of it is impartiality and the ability to engender and maintain trust. Strong communication skills will be very useful, and business acumen and adaptability will also be, in a commercial context, be extremely useful. Otherwise, business people think very quickly. They generate options very fast. Legally trained minds are sometimes slow on the uptake on the commercials, and it can get very frustrating for the parties. And I've seen this before, that the lawyers or the mediator are simply not able to keep up to speed. And also creativity and imagination. And I would also add to it empathy, because at the end of the day, however commercial the situation is, you're still dealing with a human being in the room. And therefore, to be creative and empathetic while exercising nonviolent communication and generating options will lead to a very successful career as a mediator.
Thank you. That's really useful. Very useful. Thank you. Jonathan, we have about a minute before we may take some questions. So how can lawyers and in-house counsel support the mediation process constructively, please?
Okay, yes, I can be brief on this one because I have, as you know, I have already touched, I think, a bit on
Yes,
this in my previous reply. I think my general comment would be that lawyers can help the process being successful, or they can obstruct the process. So they can offer constructive support by, as I said before, shifting from an adversarial mindset to a collaborative mindset, shifting from the idea of evidence production to prove your case and towards problem solving. This is also linked with what Rajesh was saying previously, that the lawyers need to be there, but it's about the parties. It's not about the lawyers here. So that requires the change in mindset on the part of the lawyers. That could be very constructive, I think. Obviously, they need to ensure that the legal realities of the case, they need to keep them in mind. And that is precisely what the role of the lawyer in mediation is, to make sure that the legal aspects of the strict legal aspects of the dispute, the rights of the client are safeguarded. But I think, to conclude, I reiterate that the most constructive support that the lawyer can give is that change, that shift in the mindset from evidence production leading to a success winning a case to problem solving, which is the ultimate interest of the client.
Thank you. Thank you very much. If anyone has any questions for any of our panelists, please do come online now or put it in the chat box. I know that we are, with all the best endeavors, we've tried to keep to time, but as moderator, I've probably failed that. But it was very fruitful discussions we were having, so hopefully you found that useful. If we don't have any questions then, please do connect with us. We are on social media, LinkedIn, etc. And we'd love to carry on this conversation. I would just like to, on behalf of myself, I would like to thank Jonathan, Rajesh and Shreyas. Thank you so much for answering all of those questions and bearing with me as moderator. Tatovic, can I pass back to you? Is there anything you'd like to add before we end?
Yeah, thank you very much once again for your insightful points and also experiences that you have shared with us and with the audience as well, which were very, very helpful. So from my part, just great thanks to all the panelists for being with us on Saturday and for 1 hour and 20 minutes before because we joined a little bit earlier. So yeah, that's great. Thanks to everyone.
Well, thank you to Aruna for being an excellent moderator. And thank you, Tatavik and Alex.
Alex, thank you. Thank you very much. Thank you, everyone. Have a good rest of the Saturday. Thank you. Bye-bye.
Thank you.
Thank you very much. Thank you.
It was a pleasure. Bye-bye.
Bye.